Perfect. That's what I wanted to make sure. All right. So thanks everyone for coming. This is a recorded session, so you are aware. Like I said, my name is Rachel Sterling. I am the COVID-19 Eviction Response Coordinator and a housing attorney here with Homeline. I'm going to get through just a couple of quick things on who we are and what protections are still in place with the COVID-19 phase out protections, and then I will be handing it off to Jesse Anderson, who is the Deputy Director of Community Development in the City of Brooklyn Park. And we also have with us Faduma Mohammed, who is a housing organizer with ACER. They were instrumental in getting these protections passed, and so she will be here as well to help answer any questions and be available for how this process got started. All right, so what is Homeline? We are a statewide nonprofit organization. We've advised approximately 280,000 renters since we started in 1992. Our primary way that we are able to service those renters is through our free legal and confidential hotline. We offer those services in 4 languages, Hmong, Somali, Spanish, and English. At this point, we have 26 people on staff to help with that hotline, as well as our advocacy, organizing, and policy work. If you are a tenant and you have questions about your rights as a tenant, feel free to give us a call, or we also have an email, an attorney option if you prefer that. So this is a link to our phase out programs. We've been doing these for over 2 years now at this point, these webinars. And so we have quite the list of archived backlog that you can look through to see how the phase out was going and what we've done in the past. And all of that is on our website, which I will post a link to as soon as I'm done talking, which will be in a couple minutes. So getting into the nitty gritty, first things first, the big thing is that Rent Help is no longer accepting applications. The important part about this is that if you submit an application with Rent Help MN before January 28th, which is when they stop taking applications, it will be reviewed and they will be processed. From what I've heard, they are anticipating that they will be processing applications for several more months to come. So why is that important? There are the only other program that was available right now is Ramsey County Rental Assistance Program to Ramsey County residents, say that 10 times fast. But they are closing their program as of Friday, April 15th, or excuse me, not closing the program, but they're going to stop taking applications after Friday. So if you're a Ramsey County resident and you need rental assistance, you should go to apply for that sooner rather than later. So then the phase out. What is the phase out? Like I said, we've been doing these now for almost 2 years. The phase out is essentially what's in place to phase out some of the limitations that were put in place from the eviction moratorium that Governor Walz put in place back in 2020. Most of those restrictions have been lifted. There is one lingering protection for renters. Essentially, if you have a pending application with one of those COVID-19 emergency rental assistance programs, that would be Rent Help if you applied before January 28th, or with the Ramsey County, if the Ramsey County Emergency Assistance COVID-19 program, if you apply for that before the end of this week, then you would be considered to have a pending application with one of these qualified programs, and would mean that your landlord could not evict you for non-payment of rent while you have that pending application. So if you have a pending application with one of these programs, then you need to make sure that your landlord knows about it. You should get some sort of confirmation letter or something along those lines that you can share with your landlord, letting them know that you have this protection, that you're in this pending status. If you do have an eviction that is filed against you, It is critical as a tenant that you show up to the initial hearing so that you can present the court with this paperwork showing that you have this pending application, because otherwise the court is not going to know about it. So again, can't stress this enough. It's super, super important to show up to the court hearing. Otherwise, regardless of whether you have a pending application or not, the court's not going to know about it, and you'll get a default judgment against you in most cases. One of the things that was talked about here was there was some pre-eviction notice requirements with the phase out and the eviction moratorium. Those, for the most part, have gone away. There are some city level pre-filing eviction notice requirements that have been instated since though the state level one has expired. And so if you are a resident in St. Louis Park, Minneapolis, or in Brooklyn Center, which we will get to more later, there is a pre-filing of an eviction action notice that a landlord has to give to a tenant. Now, for St. Louis Park and Minneapolis, that is just for non-payment of rent evictions. And for Brooklyn Center, though, it is non-payment and for material breach evictions. There are also some federal level pre-filing eviction notices for certain types of properties. In the CARES Act, there was a requirement that just never sunsetted that said that for CARES Act covered properties, that's going to be properties that fall under the Violence Against Women's Act, federally funded properties, properties that have a federally backed mortgage, that sort of thing. Then there has to be a 30-day notice given before a non-payment of rent eviction can be filed. HUD recently passed a very similar requirement as well. Again, for specifically for HUD housing providers, that they must also give a 30-day notice to their public housing and project-based rental assistance tenants before an eviction can be filed for non-payment of rent. What makes this one slightly different is that it is also required that the landlord includes information about local emergency rental assistance programs. So that's something that the CARES Act doesn't require, but is something that these HUD requirements do have. All right, and then, so that's kind of what's happening with the COVID-19 eviction protections. We wanted to give kind of a sneak peek, I guess, at some of the numbers that we're seeing. One of the things that Homeland has been doing for a little over almost a year now, I guess, is we've been tracking evictions. And so this is a snapshot of what is happening specifically for eviction reasons. So the highlight here is that yellow line that's at the top, that's way above everything else, that's evictions for non-payment of rent. You can see everything else at the bottom, the breach of lease and holding over evictions are kind of on par with each other. And then below that are some of the other less common reasons to file an evictions, but non-payment of rent is far and away beyond what all the other ones are as far as reasons why landlords are filing evictions. And what that looks like in raw numbers is this. So this one goes back to October of last year. The last slide only went back for 2022, so January through March. But you can kind of see October through December fairly steady, excuse me. But then we start climbing starting in January. And then this last month was quite a dramatic uptick in evictions being filed. All right, so this is just data that we're pulling. If you go back to pre-2020 eviction numbers, it's about 15,000 evictions were filed in 2019, which averages out to about 300 a week or so. And in March, we started climbing above that average per week. So it's a trend that we're seeing and anticipating that April will be of similar numbers. So I hate to leave it on that kind of downer, but I wanted to move along quickly to the reason that we are all here today, the Brooklyn Center Tenant Protection Ordinance. I threw this slide in here mostly just to have the city code section number and a link to some of the language for folks who are interested in that sort of thing. I know some people, myself included, are kind of nerds about it, so it's helpful to have the information there. But again, without further ado, I am going to step back and stop talking and let Jesse take the reins here. Or I will go ahead and advance the slides, Jesse, but I'll let you get on with your work. Thank you.
All right. Again, good afternoon, everybody. Thanks for being here to listen to this little presentation here. So yeah, Brooklyn Center Tenant Protection Ordinance. I'm Jesse Anderson, Deputy Director of Community Development for the City of Brooklyn Center. Next slide.
And I forgot, I apologize. We do have a Q&A option. Sorry, we will have Q&A after this. If you have questions or anything that comes up, please put your questions in the Q&A chat box. Not the chat box, the little Q&A function that's at the bottom of your screen. If you put them in the chat, I will probably miss them. And so I'll feel badly about it afterwards. But if you do have questions, please put them in the Q&A set and we will get to them after Jesse is done with his portion. So thank you.
You can next slide. There we go. Okay, so just a few trends. So Brooklyn Center, kind of started talking about this. I believe it was October, November of 2021. We started having discussion about tenant protections, which was part of a greater discussion surrounding tenant protections. But we were definitely kind of tried to expedite the process a little bit with the eviction and the non-renewal because of the ending of the eviction moratorium along with the low vacancy rates. But as you can see that, average vacancy rate across the region was 2.3 with a high demand for rental housing and unmet supply. And some of the effects we're looking at increased rent, increased rent from what's considered a Class B or Class C rental properties, which are basically landlords looking to maybe upgrade to a non-affordable unit. And then landlords would be in a position to be choosier about who they rent. And then also more property owners, managers looking at not accepting Section 8 vouchers. So some of the trends we were kind of seeing before when we started to move this ordinance forward. Next slide. And then just a real quick map here that shows that you can see like the vacancy rates from 2010 to 2020, where, there definitely is a fairly drastic decrease in the amount of vacancies across the country even. Next slide. Okay, so Brooklyn Center's housing stock, 30% of Brooklyn Center's housing stock is rental properties. We have approximately 829 properties that are rental properties in the city, with approximately 4,340 units within those 829. So about 8% of single family properties in the city are rental properties. And nearly all of ours are considered, we can go back, there we go. Nearly all of ours are considered naturally occurring affordable housing. So, and their average rent is affordable between 50 and 60%. 6% of all housing units are, we only have 6% that are legally binding affordable. So basically, like I said, almost all of our rental housing in Brooklyn Center is considered affordable. And of those, only 6% is legally binding affordable. And basically almost all of our rental units were built from 1961 to 1979. So they're very, very similar in build, mostly 1 to 2 bedroom units. Next slide. So again, we're hearing a lot of concerns from tenants about rental properties in the city and maybe even across the metro probably. And this is some of the things that people are saying. Renters being a month-to-month rent, rent increases, rent increasing, incomes aren't increasing. So there's a lot of different things that we've heard from tenants through the last couple of years. Next slide. Okay, so Brooklyn Centers actually has had like a rental licensing program since like the late 70s, 1970. But we've done actually quite a bit with rentals in the city. In 2009, 2010, we adopted a kind of a performance-based licensing program. In 2018, we did adopt a tenant protection ordinance, but that was specific to change of ownership. Whereas, so to help to prevent landlords or property managers or owners from purchasing a property and then basically evicting or non-renewing or all of their tenants and so that was an ordinance that was in 2018 that was adopted, that was specific for new buyers to affordable rental units in Brooklyn Center. Next slide. All right, next slide. Want to skip to the next slide, please?
Wonder if we've lost Rachel for some reason.
All right, well, I can probably, we did, okay. Maybe I could switch to share my slide.
I think I just became the host. It looks like we did lose Rachel. So if you cannot share, I can probably give you that ability.
Oh, it looks like she's back on, so.
I apologize for that. I have no idea what happened.
Okay.
All right, let's try that again.
We're on slide 7 now.
Okay.
Oh, it says 19 at the bottom. So,
Is it?
okay, yep, all right, so.
This one still?
Yep, that's the right
Okay,
one. Yep.
perfect.
So, okay, so basically, starting October, November, we started working on a two kind of main parts of the ordinance. One is 30-day pre-eviction filing notice. The other is a just cause non-renewal. So I'll start with a little bit about the pre-eviction filing notice. So it requires a 30-day notice prior to the filing of an eviction on an affordable unit. So a notice can be for alleged non-payment of rent, or notice can be for an alleged material breach of lease. So there's only one exemption, and that's based on the state statute, that when there's illegal behavior that seriously endangers the safety of others. So probably not a likely situation that that's probably going to occur, but if there was some type of illegal dangerous situation occurring, the 30 days there could be an exemption. But it can be, again, 30 days notice for non-payment rent or material breach of lease. So, all right, next slide. So it does have requirements for those notices. So if it's a past due rent, they must include name, mailing address, phone number of the person who is going to receive the rent that's owed. It needs to say what the past due rent is, what the late fees are, and any other charges. And with a due date that is no earlier than 30 days from the delivery date of the notice. And that's based off the delivery date. So material breach of lease, basically the same thing, but it does need to provide a full description of the lease violation, including the dates, who committed the violations, and then must identify how to correct the violation. And it needs to include a copy of the lease. All right, so that's the notice for that. Next slide. Okay, so the next that was adopted was the just cause non-renewal. So basically, there's no exemption really. Well, actually there is a few, but so the only way to have a tenant non-renew, so their lease is expiring and the landlord wants to non-renew them, they can only do it for these reasons. So non-payment of rent, material breach of lease, non-compliance with that, or if the tenant themselves refuse to non-renew. If the unit is going to be occupied by the property owner or a family member of the property owner, or if it's going to be demolished, or for a major rehab, and complying with the government order to vacate, or like if there was some type of occupancy was conditioned on employment, if maybe they were like a maintenance person and they were no longer a maintenance person, that would be an exemption to the non-renewal. So, but generally speaking, for a tenant, the only way they can be non-renewed is for non-payment of rent, material breach of lease. If the tenant refuses to non-renew, those are the main reasons that a landlord can choose to non-renew a tenant, and they have to provide notice of them about that. So next slide. Okay, so basically, if for any non-renewals, they need to include the language on the left side of your screen. I'm not gonna read it, but that is required language for the non-renewal. And then they have to comply with all notice requirements under the lease and applicable law. So if they're gonna non-renew for a just cause, they need to follow all the requirements of the lease, include a written notice, which includes the reason for the non-renewal and the facts that support those reasons. And the owner must maintain documentation, totaling number of notices. So the city can request documentation from a landlord on how many non-renewals they're doing or what their non-renewals are for. All right, next slide. Okay, so the ordinance is based off of the unit. So a tenant does not have to try to calculate whether or not they are, if their current, the tenant does not have to determine if their current income is considered an affordable, because it's based off the rent. So it's based off of HUD's determination for 80% of the area median income. So this is the current numbers. I believe they're scheduled to change soon, but these are the numbers. So even if you don't believe that even if your income exceeds 80% of the area median income, but your unit maximum rent does not exceed the 80%, the unit still qualifies for the just cause non-renewal, if that makes sense. So these are the kind of the numbers for the common unit sizes. All right, next slide. Okay, so there's a couple little other provisions of the ordinance. A waiver is not allowed by a tenant to waive their rights under the new ordinance. So if a landlord was trying to encourage a tenant to say, I want to non-renew, or bottom line is the landlord can't force a tenant to waive their rights. So a tenant can't waive their rights to the ordinance. And it's the way the ordinance is written, it's designed for private enforcement. So basically a person harmed by an owner in violation of the ordinance may bring action against the owner in district court. And basically a lot of times this ordinance is going to be used in a court hearing, possibly if there's an eviction, where a judge would probably throw out the eviction if they didn't follow the ordinance correctly. So, all right, next slide. Okay, that's just kind of a general summary of the ordinance. I know there's a lot of provisions. It's a lot more than just that. But generally speaking, a landlord has to provide notice of non-renewal and have a reason to non-renew a tenant. And if they're going to file an eviction, they need to give a 30-day notice. So that's the general provisions of it, and that's kind of how it works. I know we're going to have a question and answer time here, but I also just want to provide my contact information. If anybody would like to contact me and discuss it further, I'd be happy to do that too. So that's all I have for a formal presentation. Are we question and answer, or are we moving on to other presentations?
That's it for presentation stuff. We wanted to leave, we know that this was brand new. We want to leave a bunch of time for questions and anything about that. I know we had one question pop up in the Q&A. You were very timely on that, Jesse, with asking what affordable meant. So it's, long story short, it's based off of HUD's guidelines is how they define affordable housing, right?
Yep, HUD's guidelines for Twin Cities housing based off the unit. So it has nothing to do with the actual tenant's income. It has to do with the cost of rent.
Okay.
And then Jesse, can I also clarify the way I read the Brooklyn Center ordinances, and I might be wrong here, but under the Brooklyn Center definition, it also applies only to multifamily rental dwellings that have 3 or more dwelling units.
I believe this ordinance is for all units in the city. The tenant protection related to sales, I believe, is only 3 or more units. But the tenant protection related to 30 days notice or the just cause non-renewal is all units. All rental units in the city that are affordable.
Awesome, thank you. So Carrie, it looks like in the chat, is asking if they can have a copy of the slides. We will be posting a recording of this to our website once this is done. And we'll discuss whether it's going to be, if we can make a PDF available of these or not later. We will also, just so you know, we are going to apply for CLE credit, I think, for this. So for you lawyers in the audience. Jared is one, I'm sorry.
Oh, I was just going to ask the what is the effective date question?
It's a great question. We had that question as well, because we got 2 different answers, Jesse.
30 days after the ordinance became effective, which I believe was, let me just get that exact date here for you. I believe it is effective now. Let's see, when did we vote it in here? I lost my copy of the ordinance.
Because it became effective, or it was voted on by the council on February 28th, correct?
Yep, so I believe March 28th is when it became effective, but there could be a provision about when it was actually posted 30 days after it was posted. So if still it is in effect now. So
The website says effective on April 4th.
That's probably, yeah. So it must have been published on March 4th, which means 30 days from publication. So April 4th. Yeah, that sounds right.
Okay. Perfect. Okay. Well,
I actually have an additional question for Jesse here,
perfect.
because it's something I'm personally curious about. You mentioned that there is a private right of enforcement, which is great. I think that will be very helpful to tenants, but it does also say in the ordinance, if I'm reading it correctly, that there could be adverse license effects, administrative fines, or other penalties. And I mean, as we just discussed, this is only effective as of about a week ago, so maybe the city doesn't have an opinion on this yet. But if the city receives notifications of violations, especially like serious or building-wide violations, does the city have any plans in place for taking adverse rental license effects, or is that something you guys are still thinking about, what that would look like?
I mean, I think that specific to this ordinance, I think that if we saw a trend occurring at a apartment, that I think if we had complaints about this occurring regularly or at all, our first step would be to request the documentation on the non-renewals from the apartment. And if we did see a trend or an excessive amount of violations there, we probably could take licensing action. A lot of times we like to try to take actions where we won't issue a license for known violations without like an improvement plan. So we may require them to have a plan to follow the ordinance before issuing a new license. But we could, but I don't know if it would be necessarily on a case-by-case basis, but probably if we're seeing a high level of violations being reported by this ordinance.
Thank you for that. One question that I had maybe for Fuduma is how how long did it take from when you all were starting to, Jesse talked about some of the issues that were going on in the community, but, what was the length of this process for y'all for getting from one to final?
So I was involved for about 2 years, but I think the whole process was even before me, because community had concerns, but at first it was kind of slower, and then the last year is when it really picked up, and became much more tangible, and then became something real. But yeah, several years.
Okay. And I'm
I can elaborate on
assuming,
that if you want.
yeah, please.
So it sort of started, I believe, with years ago with, I believe, Acer making requests to multiple agencies across the metro about different ordinances. And I think in 2018, when we first brought forward the initial tenant protection ordinance around the sale of a property, I think that's when the discussion started. So that was our first step, was the preventing the adverse effect of a sale. We had work sessions with council and discussed kind of the greater picture of a lot of different things about ordinance. We're discussing possibly increased regulation related to maintenance fees. We've discussed different things like that. And this one, with the eviction moratorium kind of in the pandemic, and also the St. Paul lawsuit was kind of pending to kind of see where that was going to land. So, but with the eviction moratorium ending, we kind of put this to the top priority for some tenant protection regulation, and moved it relatively quickly. I mean, it was probably longer than it could have been, but we tried to expedite the process for these specific provisions relating to the expiration of the eviction moratorium.
Thank you. Slight follow-up to both of you as well. Are there any plans in place for how to essentially get the word out to landlords and tenants about the new ordinance and some of the protections that are in place? How are they going to know about it?
Yep, there's a lot of things in works for that. So one, we're kind of putting together a brochure that'll cover the data. We've gotten some information already from Acer. I think it's helped with a little bit. But we are planning to hand deliver that information to every apartment unit in the city through our inspection staff that's out doing rental inspections. We plan to disperse flyers to every unit. And then the city newsletter as well, putting in our website. We have some e-notifications that we're going to probably build in. And then also, as far as the landlords, we have every other month we have a meeting with landlords. So we'll definitely be presenting information on that, as well as a newsletter to the landlords. So it's definitely something that's been a priority to get the information in everybody's hands. So we also do, and maybe annually, but maybe every 2 years approximately, we'll do like a kind of a tenant handbook that we'll send out, and we'll definitely include that in the next version.
I didn't know about that.
It's
Good to
relatively new, yeah.
Well, so we do tenant education and leadership cohorts. They're like a group of people that we go through like 8-week process. And so definitely implementing it in that cycle, and for all the tenants that we come into contact, to let them know. We have a flyer that we produced in-house that has all of the different aspects of the ordinance, and so giving that out. But yeah, just the regular way that we connect with renters. I wouldn't say that we are as extensive as the city, because the city, I think, knows like all the different addresses, but we really work with apartment communities that are more vulnerable. So we let them know the information when we are in community with them.
And is there a place that both either tenants and landlords could call if they've got questions about what to do for how this
Just
works.
our regular office number, or like my office number. I can put that in the chat. Is that fine? Oh.
That'd be great. Jesse, is there any place at the city that people can call just for clarification, or is it going to be just
Sure.
just your number?
You can call my number, but also our main department, community development department, is almost the same as mine. It's 763-569-3330. That's the general number. But yeah, we're not a big department, but yes, they can contact us and we can try to help. At minimum, at least connect them with additional resources or help provide clarification. So
Sorry if we just blew up your inbox.
that's all right.
Another question that's coming in on the Q&A, is there a city entity that's going to be responsible for collecting any data to evaluate and or measure the effectiveness of or the use of the ordinance protections?
Well, we're not a big department, but I would say the community development department will try to address that as much as possible. I think that we will evaluate data through making requests to landlords, discussions about how it's working, how it's not working. And then as well as I believe we would be partnering with advocacy groups to kind of evaluate the temperature and the effectiveness of it.
Thank you. I got a sneaky question here directed at me, but for Fudumo. So at Homeline, we're definitely seeing an increase in calls recently from tenants who are under threat of displacement, basically lease non-renewals, that sort of thing. Most of that is related to the pandemic and the end of the rental assistance programs, as I was mentioning earlier. So how do you think that this new protection that Brooklyn Center has passed will help tenants impacted with these issues? And what more is needed to help keep residents housed and in their homes?
So from my perspective, I think for renters who have lived who have a long-term lease and have lived in that place for at least a year, but probably also for several years, this will definitely give them more, this will be a really strong tool to stabilize their housing, because one of the easiest ways that people have been displaced was non-renewals as a form of eviction. And so now I believe that they will be given a fair chance for whether they want to stay or not. And if they are being displaced, then they'll definitely they'll have a solid reason that they can either fight against or not. And then for people who are being evicted, like I think it will definitely help bring clear communication that you are being evicted, and there and then you have some kind of time to prepare against that. But I think there will also be some adverse consequences, to be honest. And in that by that I mean I am apprehensive about landlord retaliation. So a lot of things we were hearing was throughout the ordinance was that landlords were going to retaliate by, for example, putting everyone on a month-to-month and then just renewing that lease instead of like a much longer term lease or whatever. But we're going to keep an eye on that. But overall, that's those two things are our hope: more stability and better communication. But overall, like a balance of power is what I'm really hoping for.
Thank you. Those were very big questions. So appreciate that. Well, again, I'm going to plug out there if there's any questions that folks have on ordinance and what it means, what some of the verbiage means, how it's supposed to be delivered. We also are perfectly happy to answer regular general legal questions about COVID-19, and if you've got questions about other things, we're fairly open. I think that this is going to be, this is new, so folks are going to, going to have questions, I think, going down how this is implemented and such. So as far as in the, sorry, I'm reading through, this is a question, I guess, for Jesse, but you say in the ordinance that the pre-eviction filing notice has to be just given with particular information. Is there any restrictions on how that is to be given? Like, is a text fine? Is a email? We get questions about that all the time.
Yeah, I don't think this one has provisions about what method of delivery is approved, but I think that whatever they do, they have to be able to prove that they completed that action. So it's going to need to show that they had the proper wording, and they're going to have to prove that it's been properly delivered. So either through a copy of the letter or a photo of the posting. No, I don't believe the ordinance specifically identifies how and what method of delivery is acceptable.
There is, it doesn't put a limit on how it's delivered, but it does actually, I think if I'm reading it right, have a minimum, which is personally or by first class mail to the address of the affordable housing unit. And it can also be done in other ways. In fact, the ordinance even says that by email or other electronic means. But it doesn't sound like you can use those email, for example, in place of either personal delivery or mailed by first class. That's section E of 4. Sorry, I'm scrolling back up because it's got a lot of subdivision. That's 12-912D4E, which is the pre-eviction filing notice, then delivery of notice requirements, assuming I didn't mess up which portion the delivery notice is a part of. But
thank you, Samuel. That is exactly why you are here. We actually got, all right, so we got someone coming in. Question from Anonymous is saying, did you see an increase in eviction filings in Brooklyn Center for material breach during the moratorium? And are you concerned about landlords using that part of the ordinance as a way to improperly issue a notice of non-renewal?
I'll take this one, I think. Although, Jesse, if you have thoughts from the city, that would be good too. I don't think Homeline is specifically seeing an increase. Maybe they're having it in the courts. It's definitely a possibility. I mean, landlords already do this, where they used breach of lease as sort of an in run around non-payment restrictions. And I think we'll see it for just cause as well. It's always going to be a problem, but the good news is, at least from a legal standpoint, landlords have to now prove that. And that's a lot easier burden of proof, or a lot easier for a tenant to defend, because there's something concrete there that they can point to. Like the landlord, if the landlord's going to say you breached your lease, the landlord has to actually be able to present evidence of that breach. Compared to what it was before, where the landlord could, for example, just say, we're not going to tell you why we're non-renewing your lease. We have no obligation to do that. Good luck. Which, Brooklyn Center has this, so does subsidized housing and mobile homes, but short of those places, I mean, most landlords, that's what we see. I took like 3 calls on that yesterday. And so it's very nice to be able to say, no, the landlord has to actually tell you what the breach is. And then if you decide to fight it, they'll have to prove that in court. And again, the tenants can do this defensively or even through filing injunctions or other proactive means if they want to under the ordinance.
Yeah, and maybe to add on to that, I think there was some landlords that expressed that they would, I don't know if I'd say, I don't know how to phrase it, but they kind of implied that they may, if they can't non-renew, they'll just evict. And since they can't non-renew easily, but I don't personally believe that a landlord who has enough documentation to non-renew with just cause would opt to evict over a non-renewal, because even if they have the document to prove it, doesn't mean they're going to file an eviction. It's still easier for them to non-renew if they have the proper documentation. So I don't believe that's a valid reason that we would see an increase. So I don't see an increase because now they have better proof. I don't see that as a reason that they would increase evictions. I think they would, if they had proof, they would still prefer to non-renew with just cause over an eviction, even if they could file an eviction, if that makes sense. So I don't see that as being a reason to increase evictions.
Okay. Dorinda is also wondering, does the ordinance require that an eviction complaint filing include the notices of the allegedly provided to comply with the ordinance, or will the tenant have to raise the issue in court?
I don't know if you want to answer this one or not, Samuel, but I believe that the tenant would have to raise the issue in court, but I believe the courts will be made aware of the ordinance. So
Yes, that's my understanding as well. I don't remember, I'm like scrolling through again just to see if I missed something, but I don't remember anything in the ordinance that requires it. And as a practical note, I'm not sure the city could have. I don't want to step on the city's toes there, but what a complaint has to include is defined by state law. And so I don't, again, in scrolling through this, I don't see anything that I forgot about. So it is, if the tenant's going to use it as a defense in an eviction, it is something they're going to have to bring up. I can't speak for the court either, but I hope that we'll see the court do the same thing that they're doing for Minneapolis and St. Louis Park, which is ask about the notice when they see court cases from this city, from Brooklyn Center.
We had referee Cedillos on last month talking about some of the new ordinances that were coming into play. And she did touch on this one as well, since it had just passed recently. And so I can, they are aware of it at the very least. And I didn't get any indication that they would be treating it differently than they have been for the St. Paul and St. Louis, or St. Louis Park and Minneapolis ordinances that are in place, at least at Hennepin County. So Samuel, I think kind of raises the question as well of speaking of what a tenant has to provide or not. So say that landlord gives a notice of non-renewal just cause, saying that they owe money or something like that. How does a tenant dispute the amount or what's in the notice of non-renewal during that 30-day?
I mean, I think that there's two possible ways that a tenant could do it. One way would be to simply do nothing, or I mean, not do nothing, but do nothing legally, respond in writing saying, no, you don't meet the requirements, I didn't breach my lease, or I'm current on rent, whatever it might be, and then take no additional action. Don't move out, don't do anything. And basically call the landlord's bluff, see if they're willing to go file an eviction and fight this in court. And then if the landlord does, the tenant will basically have a chance to force the landlord to prove their underlying complaint. That would be one way. My guess is we'll see a lot of that, simply because it is easy for an unrepresented tenant to do. But the statute also allows for proactive action by the tenant, such as seeking an injunction. This is a little bit difficult, I would say very difficult for an unrepresented person to do, but it is the type of thing that, especially if this were done on a building-wide scale, legal aid or other legal agencies might get involved, filing an injunction against the landlord to determine this proactively, so that those evictions never get filed. And sorry, I scrolled away from this in the ordinance. Let me get back to it. But as part of that court case, they can also seek a reasonable attorney's fees and expenses. So I think that in cases where it gets the attention of, again, legal aid or a law firm doing pro bono work, or even just an attorney, a private attorney, because as Jesse pointed out, this applies to the affordable definition applies to the housing, not to the tenants or their income. And on top of that, the fact that the tenant gets to ask for attorney's fees means that there might be attorneys who are willing to take these cases, with no charge up front, on the grounds of being able to hopefully get some of their attorney's fees paid on the back end. So you might see injunctions or those types of court cases filed against the landlord proactively, so that the tenant never has to go through the eviction.
And one of the nice unique things about the Brooklyn Center ordinance is that it is 30 days long for the notice. And so that gives more time for action, either going, as I was saying, with the injunction route, or frankly, just discussing, coming to some sort of agreement or talking it out with your landlord to avoid an eviction, being filed in the first place. A landlord is the one who has the power to not file if they don't want to. So
yeah. I mean, I can say that as a practical matter, we see something very similar to this in subsidized housing quite regularly, because subsidized housing has a 30-day notice requirement effectively for most things. And that's before they file an eviction, before they do a lease termination. So what happens often is they give these notices, and the tenant either disputes them completely and therefore doesn't move out and sees what the landlord does, or often in cases that are gray, where the landlord has some fairly good evidence that will establish, or at least likely establish, some lease breaches. Often what happens during that 30 days is the tenant and the landlord come to some sort of an agreement. I'm thinking of a recent person that I talked with, where there was some fairly serious allegations that the tenant completely disputed, but that the landlord was at least alleging they had numerous witnesses on. And if the landlord could prove it, it definitely would have been grounds for non-renewal. And so, what happened during that 30-day time frame is the landlord and the tenant met, and they agreed on a move-out date that was actually a little bit beyond the 30 days to give the tenant additional time. And so it was resolved without ever having to go to court. And again, the tenant was saying all of these charges were made up. The landlord was saying, no, they're not, and we've got plenty of witnesses. And so I can see that happening as well in Brooklyn Center when you have, contentious allegations where, maybe the tenant doesn't agree with all of them or none of them, but the landlord's got some evidence on their side.
perfect. Thank you. Well, we are coming up on 2:30. We have half an hour more scheduled, which we can use, or if anyone has any other questions they want to ask, while we have a captive audience of Jesse and Samuel and Fiduma. Otherwise, I am going to say quick, we are planning on continuing these webinars into the future. We haven't solidified our next one, should be some point next month. We're hoping to have that in. So we are going to be continuing these. So look for information on what should be coming up next. But yeah, I don't see any other questions coming through in the Q&A or in the chat. So I think at this point, if again, if you do have questions that you want to reach out about, feel free to call Jesse or Fiduma or our hotline at Homeline. And thank you everybody for coming today. I hope you have a great rest of your day. Thanks so much. No, stop.